Good morning.
Morning, Judge.
How are you?
I'm doing well, thanks. How are you?
Pretty good. Let's see. They should be logging in shortly. I think they're having a challenging day down there today.
That's what they told me doing the polycoms.
Yeah.
They're going to tell you to formally go to your next court date. Okay, so between today and your next court date, you're going to meet your attorney, tell your side of the story, and say, "Hey, this is bunk. This is why I think the charges should be dropped," and we'll go from there. When you go up, please remember no hats on when you go up and see the judge. Okay, and try things like don't mess around. The next person.
Me?
Yes, we can hear you, Your Honor.
Oh, thank you. Okay, I'll start with Hakeem Speed. This is people of the state of Michigan versus Hakeem.
1 second, Your Honor. We'll get him.
Is he in there? I can do someone else.
He will be in here in 2 seconds.
Oh, okay.
And there's a. Just a second.
No problem.
Okay. He's coming. He's just. Right over the table, sir.
Okay, you're Hakeem Speed.
Yes, Ryan.
Okay, state of Michigan versus Hakeem Speed in file number 25-0083 SM. Appearance, please.
Good afternoon, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Mr. Hakeem Speed, who is appearing from the Lansing Jail Arraignment Room via Zoom.
Mr. Speed, I have a PA 53 bond violation here. It's a complaint of violation of conditional release alleging that you violated your bonds out of the B District Court by committing the following action: that you were not to commit any crime while released. And there's allegations that on or about April 11th, that you violated that by having it says unwanted upgraded fight at the area of 5507 Joshua Ave, apartment 15. And so you have the right to have a contested hearing on the violation allegation, and the right to be represented by an attorney at that hearing, and the right to have the prosecution prove each or prove the violation beyond a reasonable doubt. You understand that, right?
Yes, Your Honor.
It's also my understanding that new charges may be pending as a result of the alleged violation. They have not yet been completed if it is going to be issued. Nonetheless, you are going to be remanded for the purposes of seeing 54B District Court, okay?
Yes, Your Honor.
Let's see what we have here. I have an address for you at 607 East Michigan Ave. Is that accurate?
Yes, Your Honor.
What's your phone number?
507-305-1332.
Counsel, did you want to add anything to the record at this time?
Nothing further, Your Honor. Thank you.
Okay, and for the record, I am entering a not guilty plea as to the violation. He'll be remanded to Judge Greenwald on that matter. You're all set for today, Mr. Greenwald, on this case. Mr. Speed, you're all set on that one, that is. Thank you. Okay, let's see, I think this is Devontae Brown. On the record, in the matters of the people of the state of Michigan versus Devontae Brown, and file number, I have one without a file number, and then I have 25-00984. Counsel appearance, please.
Good afternoon, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Mr. Devontae Brown, who is appearing via the Lansing Jail Arraignment Room on Zoom.
Okay, Mr. Brown, I have a felony complaint here. The allegations are that on or about April 12th, 2025, at the area at or near Armstrong Road near Cedar Street, that's in the city of Lansing, Ingham County, state of Michigan, that you did allegedly commit the act in count 1 of weapons carrying concealed, and that you did carry a dangerous weapon, that being a handgun, either concealed on or about your person, and whether concealed or otherwise in a vehicle operated or occupied by said defendant, that vehicle being a black Dodge Charger, and that this was contrary to Michigan Compile Law 750.227. Count 1 is a felony. Maximum penalty is 5 years in prison or $2,500, and there's a mandatory forfeiture of weapons or device required under the law. There's a count 2, assault with a dangerous weapon, that's being a felonious assault, alleging that on or about April 12th, 2025 at Armstrong Road at or near Cedar Street, Lansing, Michigan, that you did make an assault upon a Shauna K. Watson with a dangerous weapon, that being a handgun, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. And this is a felony. Maximum penalty 4 years and or $2,000. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There's a weapons felony firearm attached here. It says in count 3 on or about April 12th at Armstrong and Cedar, city of Lansing, Ingham County, that you did allegedly carry or have on your possession a firearm, that being a handgun, at the time that you committed or attempted to commit the felony of assault with a dangerous weapon, contrary to MCL 750.227B. That's a felony. Maximum penalty 2 years consecutively with and preceding any term of imprisonment imposed for the felony or the attempted felony conviction, and a mandatory forfeiture of the weapon or device. Count 4, weapons, firearms possession by prohibited person, alleging that on or about April 12th, 2025 at Armstrong and Cedar and City of Lansing, Ingham County, you did possess a firearm when ineligible to do so because you had been convicted of felonious assault, a specified felony that is punishable by imprisonment of more than 1 year, and the requirements for regaining eligibility had not been met. And this is contrary to MCL 750.224 F6. That's a felony maximum penalty, 5 years and or $5,000, and a mandatory forfeiture of the weapon or device is required under the law. There is an habitual offender fourth offense notice in this complaint. It says, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about December 12, 2018, he was convicted of the offense of larceny of a firearm in violation of MCL 750.357B in the 30th Circuit Court. Are you talking to someone over there, sir?
No, my paper was about to fall, so I had to catch it.
Oh, okay. Larceny from a person in violation of MCL 750.357B in the 30th Circuit Court, Ingham County, State of Michigan, and that on or about July 8th, 2013, he was convicted of the offense of child abuse second in violation of MCL 750. You can put is there a table in front of you?
Yeah.
Okay, well then you put the paper there, because while I'm addressing you, you can't turn around and start addressing someone else. This is not for my benefit. I'm not being charged with 5 felonies.
5 felonies.
Here, as you have an habitual offender notice, it's enhancing your penalty to life if the primary offense has a penalty of 5 years or more. How much does your primary offense have a penalty of, sir?
5.
So that means you're facing life then, correct?
Yes, I think so.
So then you probably want to pay attention. Okay. On or about July 8, 2013, he was convicted of the offense of child abuse second degree in violation of MCL 750.136B3. That's in the 29th Circuit Court for Clinton County in the state of Michigan. And then also on or about July 8, 2013, he was convicted of the offense of felonious assault in violation of MCL 750.82 in the 29th Circuit Court for Clinton County, state of Michigan, and therefore the defendant is subject to the penalties provided by MCL 769.12, life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. You understand each charge read there and the maximum penalties attached, as well as the enhancement from the habitual offender notice, correct?
Yeah.
File number 25-00984 is a misdemeanor complaint. The allegations are that on or about March 20th, 2025, at the area of 908 West Miller, City of Lansing, Ingham County, you did make an assault or assault and battery upon a Kelsey Lee Alvarado, an individual with whom you have a dating relationship, and that this was contrary to MCL 750.81. There's a second offense notice. It says, take notice that the defendant was previously convicted of assaulting or assaulting and battering his spouse, former spouse, an individual with whom he had a dating relationship. an individual with whom he had a child in common, or a resident or former resident of his or her household, or by violating MCL 750.812 on or about December 14, 2018, and therefore upon conviction will be subject to an enhanced penalty of 1 year and or $1,000. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge in that file and the maximum penalty?
Yes.
You have the right to be represented by counsel. If you can't afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public. You have the right to be represented by an attorney at all of your court appearances and if questioned by law enforcement. You have the right to remain silent, and anything you say, anything that you put in writing can be used against you. You can plead guilty, you can plead not guilty, or you can stand mute. If you stand mute, this matter will continue all the way to a jury trial. Each file will continue to a jury trial. And your felony charges, you have the right to have a preliminary examination within 21 days of the date that you are arraigned, unless you waive the 21 days or the court finds good cause to go beyond the 21 days. You understand your rights so far?
Yes.
You have the right to require that the prosecution at the time of your examination establish sufficient probable cause that the felonies was committed and the probable cause sufficient to charge you as the person who committed the felonies. In both cases, again, you have the right to a trial and you have the right to jury trial. You have the right to the presumption of innocence and to be proven guilty by proceeding to trial and having the prosecutor prove each element of each of the charges being brought against you beyond a reasonable doubt. You can maintain your silence at trial, or you can waive it and testify if you'd like. You have the right to subpoena witnesses to testify on your behalf, the right to put forth evidence to show a defense to the charges being brought against you, and you have the right to see, hear, and question any other witnesses the prosecutor calls to testify against you. You lastly have the right to be considered for pretrial release from custody, but we will address your bond in just a moment. Do you have any questions at this time?
No, ma'am.
In the felony file, you are scheduled to have a probable cause conference before Judge Stacia Buchanan, April 25th at 8:15 a.m. You have a preliminary examination in person at the court before Judge Buchanan, May 2nd, 2025 at 9 a.m. In your misdemeanor file, you are scheduled to have a pretrial. You can appear in person or via Zoom before Judge Cynthia Ward, April 29th at 10:30 in the morning. And I assume you received your notices to appear and Zoom instructions for both courtrooms, correct?
Yes.
Okay, let's see. Is he requesting the public defender to represent him in these files?
He is, Your Honor.
The court's going to enter a plea of not guilty on your behalf on both files. What's your address?
908 West Miller.
Is that the address where Ms. Alvarado lives?
I mean, that's the address I was living at. I don't have any other address unless you, I don't know what else you
Is
want me to
that the
put
question
down.
I asked? Is that the question I asked you?
No.
Answer the question I asked you.
Yes, it is.
Okay, well then you can't live there. Where are you going to reside?
5321 Granger.
Grant, you said 5221 where?
5321 Granger Drive, Lansing, Michigan, 48911.
532 Granger. What's your address? What's your phone number?
I don't have a phone. You can put 517-554-6339.
Are you employed?
Yes,
Where?
but it's Sir Pizza.
Which one?
It's the one on Cesar E. Chavez. I don't know the exact address, but it's in Old Town.
Oh. Are you currently on probation or on parole?
No, I'm not.
Do you have any other criminal cases pending? That was a question. Do you have any other criminal cases pending, sir?
No.
Counsel, you can address bond.
Thank you, Your Honor. I would ask that the court institute a reasonable cash surety Brown for Mr. Brown. We did hear that he is employed. He also has an alternative address that he can stay at. Despite his criminal history, he reports that he does not have a record of non-appearance in court, having made his court dates. He's a longtime resident of Ingham County, and we've heard him state that he's not on probation or parole. So I think a reasonable cash surety bond would be sufficient with the appropriate conditions to protect public safety and ensure my client's appearance. Thank you.
I have a bond recommendation here. It states here that the people have a concern about the protection of the public if the crime alleged involves violence towards another person. The crime charged involves the possession, use, and threat of a firearm, that the defendant has a history of threatening and or harassing behavior towards victim or witnesses, that there is an intimate partner or history of intimate partner relationship involved in this particular case. Other factors associated with the risk of lethality in this case include stalking behavior and a recent separation or divorce. The people are requesting a significant bond that will protect the victim and society with certain conditions. I've read the affidavit of probable cause. It's extremely concerning. I've also reviewed the defendant's prior criminal history, and I've read the affidavit of probable cause on the misdemeanor complaint. Both allegations involve threats involving a firearm being placed at the head of women that the defendant allegedly dated in the past or presently. A bond in the felony is $15,000 cash surety with GPS tether. There's no contact with Shauna K. Watson, not indirectly, not directly, not from the jail, not if you're out of the jail. Do you understand those conditions so far?
Yes.
Bond in the misdemeanor file is set at 2,000 cash surety with GPS tether. You're not to have contact of any kind with Kelsey Alvarado, not directly, not through a third party, not from jail, not from someone else's jail number. Do you understand that?
Yes,
Also, after you post bond, you have the following additional conditions. You must report to pretrial services within 48 hours of your release. You're not allowed to possess a firearm or any other weapon. You're not to travel outside the state without prior approval of the court. You're not to use alcohol or illegal substances. And you must report to all of your future court dates. Do you have any questions about your bond?
no,
Okay, any additional matters for the record, counsel?
Nothing further, Your Honor. Thank you.
You're all set. On the record in the matter of the people of the state of Michigan versus Kelsey Alvarado. Counsel appearance.
Good afternoon, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Ms. Kelsey Alvarado, who is appearing from the jail arraignment room via Zoom.
Hello,
Okay, Ms. Alvarado. Hello, how are you?
I'm all right. How are you?
I'm gonna be quite frank, I'm very concerned that I'm seeing you before my court today when I just saw you on Wednesday. And giving the things in the nature of your appearance on Wednesday and the things that you shared while on the record, it's quite concerning to see you before my court and the charges that are attached. Nonetheless, I'm going to read this complaint. It's a felony complaint. It alleges that on or about April 12th, 2025, at the area of Armstrong and South Cedar in Lansing, Michigan, that you did allegedly commit the action of carrying a concealed weapon, that you did carry a dangerous weapon, that being a handgun, concealed or on or about your person, whether concealed or otherwise in the vehicle operated or occupied by said defendant, that vehicle being a black Dodge Charger, contrary to MCL 750.227. That's a felony, maximum penalty 5 years or $2,500 in fines. Is a mandatory forfeiture of the weapon or device under the law. And there is a count 2 of assault with a dangerous weapon, also called a felonious assault, alleging that on or about April 12th, 2025 at Armstrong and South Cedar, that you did make an assault upon a Shauna Watson with a dangerous weapon, that being a handgun, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. That's a felony. Maximum penalty is 4 years and or $2,000 in fines. Your DNA is to be taken upon arrest, and there's a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 3 is weapons, felony firearm, alleging that you did on April 12th at Armstrong, South Cedar, a city of Lansing, Ingham County, carry or have in your possession a firearm, that being a handgun, at the time that you committed or attempted to commit a felonious assault contrary to Michigan Compiled Law 750.227B. That's a felony, and the maximum penalty is 2 years consecutively within proceeding any term of imprisonment imposed for the felony or attempted felony conviction. And there's a mandatory forfeiture required of the weapon or device. There is a count 4 weapons, firearms possession by prohibited persons, alleging that on or about April 12th, 2025 at Armstrong and Cedar, that you did possess and transport a firearm when ineligible to do so because you had been convicted of carrying concealed weapon, a offense punishable by imprisonment for more than 1 year, and carrying concealed weapon. it says a specified felony that is punishable by imprisonment of more than 1 year, and the requirements for regaining eligibility had not yet been met. There's an habitual offender second offense notice. It says take notice that the defendant was previously convicted of the felony or attempt to commit a felony in that on or about July 10th, 2023. She was convicted of the offense of carrying a concealed weapon in violation of MCL 750.227 in the 30th Circuit Court for Ingham County. Therefore, the defendant is subject to an enhanced penalty provided by the law that makes your penalty 1 1/2 times the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charge and the maximum penalty, Ms. Alvarado?
Your Honor.
I'm sorry?
I do, Your Honor.
I don't know if I see her. Unless I mixed it up. Oh, there it goes. Okay. You have the right in this matter to be represented by counsel. You have the right to be represented by an attorney if you're questioned by law enforcement, and you have the right to be represented if you're at all of your court appearances. If you can't afford to hire an attorney, you can make a request to have the public defender's office represent you at no expense to you. Do you understand your right to counsel?
Yes, Your Honor.
She requesting the court appointed counsel.
She is, Your Honor.
Yes.
I'm gonna enter a plea of not guilty on your behalf. You have the right to have a preliminary examination within 21 days of today's date unless you waive the 21 days or the court for good cause goes beyond the 21 days. You have the right at the time of your preliminary examination to hold that examination and require that the prosecutor put forth on the record sufficient probable cause that these crimes or felonies alleged were committed, and then sufficient probable cause to charge you as the person who committed the felonies. Do you understand that?
Yes, Your Honor.
You have the right to proceed to trial in this matter and the right to jury trial. You enjoy the presumption of innocence. So that means you're innocent until proven guilty. And you have the right to require that the prosecutor prove each element of each of the charges being brought against you beyond a reasonable doubt. You can remain silent at your trial and they can't use that against you. You can subpoena witnesses to testify on your behalf at trial. You can also waive your silence and testify on your own behalf, and you have the right to see, hear, and question any of their witnesses. Do you have any questions about any of those rights?
No, Your Honor.
You're currently scheduled for probable cause conference before me, April 24th at 1:30 p.m. You have a preliminary examination before me, May 1st at 9 o'clock in the morning. Did you get your notice to appear?
Yes, I did, Your Honor.
And you're residing at the 908 West Miller, correct?
Yes, Your Honor.
Are you employed at this time?
I am.
Where?
I just got a job at Capital City Trim Crew.
What's your phone number?
517-962-1637.
Do you have any other criminal matters pending?
No, Your Honor.
And you are not on parole at this time or probation?
I am on probation.
You're on probation?
Yes, Your Honor.
To the 30th Circuit Court?
Yes, Your Honor.
You can address bond counsel.
Thank you, Your Honor. We heard from Ms. Alvarado that she is employed. She's been a longtime resident of Ingham County, being here her whole life. She reported to me that she's got more of a limited criminal history, and only a couple failure to appears in which she claims that she did not receive notice. I would ask that the court institute a reasonable cash surety bond with the appropriate conditions to protect public safety and ensure my client's appearance. Thank you.
Bond is set in the matter of 10,000, 10% with GPS tether. There's a no contact order. You're not to have contact directly or indirectly with Shauna Watson. Do you understand that?
Yes,
You're not to be within 2,000 feet of wherever she is.
yes, Your Honor.
You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other weapon. You're not to use drugs or alcohol without a valid prescription. You need to report to pretrial services within 48 hours of your release from custody.
Yes, Your Honor.
Do you have any questions about your bond?
I do not, Your Honor.
Any additional matters for the record, counsel?
Nothing further, Your Honor. Thank you.
You're all set, ma'am.
Thank you, Your Honor.
You're welcome. On the record in the matter of the people of the state of Michigan versus Dennison Jones. Appearance, please.
Good afternoon, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Mr. Dennison Jones, who is appearing from the Lansing Jail arraignment room via Zoom.
You're Dennison Jones.
Yes, Your Honor. Good afternoon.
Good afternoon. I have a felony complaint here. Looks like it's a reissue felony warrant complaint. It states here that on or about February 8, 2024 at Malibu Drive and Continental Drive, that you allegedly committed the act of assault with intent to do great bodily harm, less than murder or by strangulation, that you did make an assault upon a Corvades Shermone Jacobs with the intent to do great bodily harm, less than the crime of murder. And this is contrary to MCL 750.84. Count one is a felony and the maximum penalty is 10 years in prison or $5,000. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count two Is a reckless driving causing serious impairment of a bodily function, alleging that on or about February 8th, 2024, at Malibu Drive and Continental Drive, that you did drive a vehicle upon Malibu Street at or near South Waverly in Lansing in a willful or wanton disregard for the safety of persons or property, and by the operation of that vehicle did cause serious impairment of a bodily function of Quavades, Shimon, Jacobs, contrary to MCL 257.6263. This is a felony. Maximum penalty is 5 years and or $1,000 to $5,000. Vehicle immobilization is mandatory unless the vehicle is forfeited, and reimbursement to the government for emergency response or expenses for prosecuting the defendant may be ordered. Count 3, police officer fleeing under the third degree under the penal code, that is, alleges that on or about February 8th, 2024 at Malibu Drive and Continental Drive, that you, being the operator of a motor vehicle to whom was given a visual or audible signal by hand, voice, emergency light, or siren by Officer Anthony Dean, a police officer who was in uniform, and the officer's motor vehicle was identified as an official police officer vehicle acting in the lawful performance of his duty, directing the defendant to bring his motor vehicle to the stop, did willfully fail to obey such direction by attempting to flee or elude the officer and increasing the speed of the motor vehicle in a way where the speed limit, in an area where the speed limit was 35 miles per hour or less. And this is contrary to MCL 750.479A3. That's a felony, and the maximum penalty is 5 years and or $5,000. The Secretary of State will suspend your operator's or chauffeur's license, and for a vessel privileged to operate shall be suspended for a period not to exceed 5 years. Count 4, assault with a dangerous weapon, also called felonious assault, alleging that on or about February 8th, 2024 in Malibu Drive at or near Continental Drive, that you made an assault upon a Quavone James Horn with a dangerous weapon, that being a motor vehicle, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. This is a felony. Maximum penalty 4 years and or $2,000 and fines. Your DNA is to be taken and a consecutive sentence may be imposed if the assault was committed in a place of confinement. There's also a felonious assault in count 5, the same date and location, alleging that you made an assault or assault and battery upon a Jamal Horn with a dangerous weapon, again, that being a motor vehicle, but without intending to commit great bodily harm or to commit the crime of murder. Both counts 4 and 5 are felonies. The maximum penalty 4 years and or $2,000 in fines. Do you understand the charges in counts 1 through 5?
Yes, Your Honor, I understand.
You understand the maximum penalty in each count, correct?
Yes, Your Honor, I understand.
Thank you. Okay, you have the right to be represented by an attorney. The Office of the Public Defender is here to represent you for your arraignment only. You do have the right to have an attorney represent you at all of your court appearances, and the right to be represented by an attorney if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the Public Defender's Office appointed at no expense to you. Do you understand your right to counsel?
Yes, Your Honor, I understand.
Is he making a request?
He is, Your Honor.
The court will enter a plea of not guilty on your behalf today. You're currently scheduled in this matter to have a probable cause conference before me, Judge Kristen Simmons. It's going to be April 24th at 1:30 p.m. You have a preliminary examination scheduled before me on May 1st, 2025 at 9 a.m. in person at the court. Did you get your notice to appear?
Yes, I have it in front of me, Your Honor.
Very good. Okay, so you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute If you stand mute, the matter will go all the way to a jury trial. And the date I just gave you for a preliminary examination, that you have the right to have that exam on that date, which is within 21 days of today's date, unless you waive that timeline or the court finds good cause to go beyond the 21 days. After your exam, you have the right to hold the exam and the right to require the prosecutor establish that they have sufficient probable cause that these felonies were committed, and then sufficient probable cause to charge you as the person who committed the felonies. If the matter continues beyond a examination stage, then you have the right to proceed to your jury trial and maintain your innocence until proven guilty, and require that the prosecutor prove each element of each of the charges being brought against you beyond a reasonable doubt. You can maintain your silence at any jury trial. You can subpoena witnesses by right to testify on your behalf. You have the right to cross-examine and question in court any of the witnesses called to testify against you. Do you have any questions about any of your rights at this time?
No, Your Honor.
Are you currently employed?
Yes, Your Honor. I started training in my first day on Tuesday at Dave & Buster's. The new one that just opened up here in Lansing.
What's your home address, sir?
2920 Mercy Lane, that's MERSEYLN, 48911 Lansing, and my apartment number 10.
What's your phone number?
517-281-3810.
Are you currently on probation or on parole?
No, Your Honor.
Do you have any other court dates pending?
Yes, Your Honor. I have a case that's been pending since 2022, which I'm on GPS tether for. I'm trying to get it dismissed, but they keep pushing my court dates back.
This is pending in 30th Circuit.
Yes. It got switched over to the annex.
You can address bond counsel.
Thank you, Your Honor. I would ask that the court consider a PR bond in this matter. As the court has noted, it is a reissue case. Mr. Jones has indicated that he does not have a record of non-appearance in court, having made his court dates. He's currently on a GPS tether already. So I think that the appropriate conditions will be able to ensure my client's appearance and protect public safety. Thank you.
Thank you. I'm not 100% sure why this is a reissue. The only thing I can assume is that maybe the alleged victim didn't appear for the preliminary exam previously. I'm not sure.
I mean, Your Honor, this is like the third time
So
that
you
it's been reissued.
you have the right to remain silent, so I need to make sure you understand that before you speak, so you don't say something that could be used against you. So you're saying this is the third time that this has been reissued. I can see that because I have your criminal history here. And
The
so
second time-
when I asked you if you had anything pending, I already knew that you had something pending. I just wanted to see what you were gonna say. You have a felonious assault pending. assault with intent to murder pending. So what's going on, actually. And then I see in 2024, these same exact charges were dismissed. And then let's see, that was in April 2024, looks like. Then again in May 2024. So I'm not 100% sure. Typically, if you're out on bond, it's not appropriate to give you a PR bond if you pick up new charges, but under these circumstances, I am going to PR you, and I'm going to give you a personal recognizance bond in the amount of 2,500 personal recognizance. While out on bond, you're not to have contact directly or indirectly with the alleged victims in this matter. That's a Quavades, Jacobs, let's see here, Pavon Horn, and a Jamal Horn. Do you understand that?
Yes, Your Honor, I understand.
You're not to be within 2,000 feet of wherever they are. You need to report to pretrial services within 48 hours of your release. You're not to possess a firearm or any other dangerous weapon. You're not to use anything else as a dangerous weapon while out on bond. You're not to travel outside the state without prior approval of the court. You're not to use any alcohol or illegal substances while out on bond. Do you have any questions about that?
No, Your Honor, no questions at all.
You need to report to all of your future court dates, and let's see. You've already been provided with your next court date before me. Any additional matters for the record, counsel?
Nothing further, Your Honor. Thank you.
Thank you. You're all set, sir.
Thank you, Your Honor.
You're
Have
welcome.
a good afternoon.
Same to you. On the record in the matter of the people of the state of Michigan versus Marino Presley Walker. I'll take your appearance, counsel.
Good afternoon, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Mr. Marino Walker, who is appearing from the jail arraignment room via Zoom.
Okay, Mr. Walker, I have a felony complaint here, and the allegations are that on the date of April 12th, 2025, at the area at or near Ohio and Taft, that's in the city of Lansing, Ingham County, that you did allegedly commit in count one, the charge of controlled substance possession of methamphetamine or ecstasy, and that you did knowingly or intentionally possess methamphetamine contrary to MCL 333.74032BI. That's a felony. The maximum penalty is 10 years in prison and or $15,000 in fines. Count two, weapons carrying concealed, alleges that on or about April 12, 2025, at the area of Ohio and Taft in Lansing, Michigan, that you did carry a dangerous weapon, that being a fixed blade knife concealed on or about your person contrary to MCL 750.227. Count two is a felony. The maximum penalty is 5 years in prison or $2,500, and there's a mandatory forfeiture that is of the weapon or device required under the law. Count three, obstructing by disguise, alleges that on the date and time in question at the area of Ohio and Taft, that you did disguise yourself with the intent to obstruct the due execution of the law, or with the intent to intimidate, hinder, or interrupt an officer or another person in the legal performance of his or her duty, or the exercise of his or her rights under the Constitution and laws of this state, that being you gave a false name contrary to MCL 750.217. And so that's a misdemeanor with the maximum penalty 1 year or $1,000 in fines. You understand the charge and the maximum penalty in each count read.
Yes.
You have the right to counsel. The public defender's office is going to represent you today for your arraignment only. You have the right to counsel if you're questioned by law enforcement, and the right to counsel at all of your court appearances. If you can't afford to hire an attorney, you can make a request to have one appointed to you at no expense to you. Do you understand that? You have the right to remain silent. Anything you say and anything that you put in writing can be used against you. You can plead guilty, or you can plead not guilty, or you can stand mute. But if you stand mute, we'll continue this matter all the way through to a jury trial. You have the right to have a preliminary examination because all but one count that you're being charged with, they are felonies. And so you have the right to require the prosecutor establish in each felony count that they have probable cause that the felonies were committed, and then probable cause sufficient to charge you as the person who committed the felonies. You understand your right to preliminary examination?
Yes.
Okay, you have the right to have your preliminary exam within 21 days of today's date unless you waive that timeline or the court finds good cause to waive that timeline. You're currently scheduled for a probable cause conference before Judge Cynthia Ward on April 24th at 8 a.m. And then you have a preliminary examination in person at the court before Judge Ward. It's going to be May 1st at 8:30 a.m. You should have received your notice to appear before Judge Ward and Zoom instructions for your probable cause conference. Is that correct?
Yes.
Okay. You have the right again to proceed to jury trial and maintain your innocence, and require the prosecutor prove each element of each of the charges being brought against you beyond a reasonable doubt. You can maintain silence at your trial and not do anything, and they cannot use that against you. You have the right to waive your silence and testify at your trial. You can subpoena witnesses that will testify on your behalf and present evidence at trial that you believe show a defense to these charges. And then you have the right to see, hear, and question any witness called to testify against you. Are there any rights that you have any questions about at this time?
No.
Are you employed?
No.
How do you support yourself?
I'm homeless at the moment.
Where do you receive your mail?
912 Call Street.
Whose house is that?
That's my parents.
Do you have a phone?
Yeah.
What's your phone number?
517-763-1493.
Is he requesting the public defender to represent him?
He is, Your Honor.
Okay, we've entered a plea of not guilty on your behalf.
Yes.
Are you talking to me or someone else?
Oh, I thought you were speaking to me.
All right, I just said I was entering a plea of not guilty on your behalf. Okay, let's see. I don't see that you have any other criminal convictions. That's accurate. Okay, wait a minute. Yes, you do. Are you currently on probation or on parole?
No.
You can address bond counsel.
Thank you, Your Honor. I would ask that the court consider a high PR bond in this matter. The alleged conduct is not assaultive in nature. Mr. Walker had indicated to me that his criminal history doesn't include any assaultive cases. He's been in the Ingham County area his whole life. He did report that he has 2 failure to appears, indicating that he was not in the state at the time the notice was sent. So again, I would ask that the court institute a high PR bond with appropriate conditions that will ensure my client's appearance and protect public safety. Thank you.
Bond is set in the amount of 10,000 personal recognizance. You need to report to pretrial services within 48 hours. Do you understand that?
Yeah.
You're not to possess a firearm. You're not to travel outside the state without prior approval of the court. You're not to possess or use alcohol or illegal drugs. And illegal drugs include any drug that you do not have a valid prescription for. You need to report to all of your court dates. And it's not our fault that you may not have an address. You're responsible for keeping up with your court dates. And if your mail is going to the 912 Call Street, then it's your responsibility to figure out what your court date is, whether you get your mail or you call the court every day or look up the court docket. It's up to you, but it's your responsibility to keep up with your court dates, okay?
Okay. Thank you.
Do you have any questions at this time?
No.
Any additional matters, counsel?
Nothing further, Your Honor. Thank you.
You're all set, sir. On the record in the state of Michigan versus Ariana Rios. Appearance, please.
Good afternoon, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Miss Ariana Rios, who's appearing from the jail arraignment room via Zoom.
Okay, Ms. Rios, you have a felony complaint here with allegations that you on April 12th at 2815 East Jolly Road, Apartment 6, engaged in the action of police officer assaulting, resisting, obstructing, and that you did assault, batter, wound, resist, obstruct, oppose, or endangered Officer Mark Fox, a police officer of the Lansing Police Department with the Lansing, I don't know why they're repeating stuff in here in all of these complaints. What in the world? A police officer of the Lansing Police Department that the defendant knew or had reason to know was performing his duties contrary to MCL 750.81D1. That's a felony. The maximum penalty is 2 years and or $2,000 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand
Yes, Your Honor.
the charge and the maximum penalty, ma'am? You have the right to counsel. You're being represented today for your arraignment, but you do have the right to have an attorney represent you at all of your court appearances and the right to have an attorney represent you if you're questioned by law enforcement. If you can't afford an attorney, you can make a request to have the public defender's office appointed to represent you, and that could be at no expense to you. Do you understand that?
Yes.
Okay. You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter is going to go all the way to your jury trial. And you have the right to have a preliminary examination within 21 days of today's date, because you're being charged with a felony, and the right to require at your preliminary examination that the prosecution establish first that they have sufficient probable cause that a crime was committed, and then probable cause that's sufficient to charge you as the person who committed the crime. You understand your right so far?
Yes, Your Honor.
You have the right to the presumption of innocence. So that means you're innocent until proven guilty, and you have the right to take this matter to trial and have the prosecution prove each element of the charge that's being brought against you beyond a reasonable doubt. You can maintain your silence at trial and not have that silence be used against you, or you can waive your silence and testify. You can subpoena witnesses to testify for you, and you can present evidence that you think show a defense to these charges. And you also have the right to see, hear, and question in court any witness that's called to testify against you. Do you understand each of those rights, ma'am?
Yes, ma'am.
And do you have any questions at this time?
Nope.
You're currently scheduled for a probable cause conference before Judge Tony Flores on April 24th at 9 a.m. You have a preliminary examination before Judge Flores. It's May 1st at 9 a.m. You should have received a notice to appear with those dates and times. Can you confirm?
Yes.
She's requesting court-appointed counsel.
She is, Your Honor.
The court will enter a plea of not guilty on your behalf. What's your home address, ma'am? It's the address on Bartlett.
Yes.
Are you employed?
Yes, ma'am.
Where?
Applebee's.
Which one?
The one on South Cedar.
What's your phone number?
517-213-5183.
I don't see anything else in her criminal history, so I assume she has nothing else pending. And that she's not on probation or parole. You can address bond, counsel.
Thank you, Your Honor. I would ask that the court consider a PR bond in this matter. We heard that Ms. Rios is in fact employed and she doesn't have any prior criminal history. She did report to me that she has been in Ingham County for most of her life. And I think that a PR bond with the appropriate conditions will ensure public safety and my client's appearance. Thank you.
A bond is set in the amount of $2,000 personal recognizance. You have the following conditions. You need to report to all of your court dates. You also must report to pretrial services within 48 hours. You can get that contact information from the jail. You're not to travel outside the state without prior approval of the court. You're not to possess drugs or alcohol or illegal drugs unless you have, or drugs at all, unless you have a valid prescription. And you're not to possess a firearm or any other weapon while you're out on bond. Do you have any questions about your bond at this time? I'm sorry, I couldn't hear you. It went out on my end.
Your
Is that
Honor.
a no? Okay, you're all set. People of the state of Michigan versus Demond Bisbee. Appearance for the record.
Good afternoon, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Mr. Demond Bisbee, who is appearing via the jail arraignment room on Zoom.
Okay, Mr. Bisbee, I do have a misdemeanor complaint here. The allegations are that on or about April 11th at 2522 East Michigan Ave, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the offense of larceny by stealing money that was belonging to an Asaya Foster. The value of the property stolen was less than $200, and this is contrary to MCL 750.3565. Count one is a misdemeanor. The maximum penalty is 93 days in jail and or $500 in fines, or 3 times the value of the property stolen, whichever is greater. To impose a fine of 3 times the value, the defendant must admit the amount, or it must be determined by a trier of fact at a trial. You understand the charge and the maximum penalty?
Yes, ma'am.
You have the right to proceed to a jury trial and maintain your innocence. You're innocent until proven guilty, and the right to require the prosecutor prove each element of each of the charges or the charge that's being brought against you. You can subpoena witnesses to testify for you. You can waive your silence and testify for yourself. And you have the right to confront and cross-examine in court any of the witnesses that the prosecutor calls to testify against you. You are currently scheduled for a pretrial before me on April 28th at 8:30 a.m. and you should have received a notice for that date. Is that correct, Mr. Bisbee?
I haven't received no notice. I didn't know about that, but the public defender probably already.
You have some paperwork in your hand. You're telling me one of those is not a notice for you to appear before me on the 28th?
No, it's nothing saying that. No.
You did not get a notice to appear?
Yes, 4/28/25.
Gonna show you what?
I got this. I see it
And you have another court date before me coming up, do you not?
tomorrow. Yes, tomorrow.
What date is that one?
That's tomorrow.
That's what I thought. Okay.
I don't know that time though. What time is that? 8:30?
Oh, yeah, I don't think you'll need to worry about it, because if you're out on bond and then I get a new case, you're not getting a PR. Counsel, you can address bond.
Thank you, Your Honor. I would ask for a low cash surety bond. Given that this is a nonviolent, non-assaultive crime. My client also reported that his criminal history doesn't have anything assaultive or violent on it, and that he's not on probation or parole at this time. Thank you.
I'm sorry, he reported what? That he doesn't have any assaultive history?
That's what he told me, Your Honor, that his criminal history is mostly related to drugs.
I've had multiple cases before Mr. Bisbee. I recently, I believe, took a plea before him. Sorry, before me. He took a plea, that is. And then I also recently know that he has a matter that's scheduled for, I believe, a final pretrial tomorrow for police officer assault, breaking and entering. And then Mr. Bisbee, has been convicted of domestic violence. He's also had other assaultive charges brought against him, including aggravated stalking. None of those ones have been brought to conviction. And so personal recognizance bond is not appropriate because you're currently on bond. And one of your bond conditions is that you are not to engage in any assaultive or threatening behavior, and that you're not to pick up any new cases. You're not to commit any criminal action. And so now there's allegations that you've committed criminal action. So now you're also going to get bond violations on any open matter. And so with that being said, you're going to get a bond in the amount of 10% with GPS tether. He does have the public defender on his other matters. I'm assuming he wants the public defender on these.
That's correct, Your Honor.
You're not to have contact directly or indirectly with Asaya Foster. You're not to travel outside the state. You're not to use drugs or alcohol. You're not to possess a firearm. You need to come to all of your court dates. Do you have an address, sir?
Ma'am, I do not have an address. I'm at the mission right now. There's a lot going on. Man,
What's your phone number?
don't have a number right now. I don't have nothing.
Okay. Do you have any questions at this time?
So I'm going to jail.
No, your bond is 10%.
All right.
Any additional matters for the record?
Nothing further, Your Honor. Thank you.
Mailing address.
Sure.
Where's my stuff going to? The mailing address? Is that going to the same mailing address that I have on hand?
You didn't provide us a mailing address, sir.
Previously, I have.
You said your information is listed as unknown.
It's listed as
You're all set.
unknown.
We'll see you tomorrow.
All right.
On the record in the matter of the state of Michigan versus Jennifer Howell Meredith. Appearance, please.
Good afternoon, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Ms. Jennifer Meredith, who is appearing via the Lansing Jail Arraignment Room on Zoom.
You're Jennifer Howell Meredith.
Yes. No.
Okay, I have here a misdemeanor complaint, and the allegations are that on April 11th at 2600 Devonshire Avenue, that's in the city of Lansing, Ingham County, state of Michigan, that you allegedly committed the act of assault or assault and battery upon a person by the name of Travis Wageman, contrary to MCL 750.811. And so that's a misdemeanor, and the maximum penalty is 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed a conviction if the assault was committed in a place of confinement. You understand the charge there, ma'am?
Yes, Your Honor.
And you also understand the maximum penalty?
Yes.
Okay. You have the right to be represented by an attorney at all of your criminal appearances in court. You also have the right to be represented by an attorney if you're questioned by law enforcement. If you cannot afford to hire yourself an attorney, you can request to have one appointed. You understand that?
Yes, Your Honor.
Is she requesting one to be appointed?
She is, Your Honor.
Thank you. Ms. Howell,
This is Meredith.
his last name is Meredith, correct? Not Howell.
Yes.
Okay, thank you. Ms. Meredith, you understand that you have the right to remain silent. So anything that you say, anything you put in writing can be used against you. You can plead guilty, or you can plead not guilty, or you can stand mute. But if you stand mute, the matter will go all the way to the jury trial. And you have the right to hold your jury trial and the right to require that at the time of jury trial, the prosecutor put forth evidence that will satisfy the burden of each element being proven beyond a reasonable doubt before you are deemed to be guilty. You understand that?
Yes, Your Honor.
You have the right to maintain your silence at your trial and not have that silence be used to prove or imply that you're guilty. You can waive silence and testify at your trial if you like. You can subpoena witnesses that will testify for you, and you would present any evidence as to your defenses to the alleged assault and battery at the time of your trial. And then you also have the right to see, hear, and question any of the witnesses called to testify against you at trial. You understand each of those rights?
Yes, Your Honor. Yes.
The court is going to enter a plea of not guilty on your behalf today. You are scheduled for a pre-trial conference before Judge Cynthia Ward. That's going to be April 29th at 10:30. And you should have received a notice to appear as well as Zoom instructions for Judge Ward. You may appear in person or via Zoom.
Okay, I've got it.
Very good. Are you currently employed?
No, not right at the moment.
How do you support yourself?
I was living with my boyfriend who I took care of his aunt, so my things were paid for.
Okay, sounds good. Where are you going to live during the pendency of this matter?
I have a friend, Stacy. I've just got to get in contact with her. She already said I could. I just don't have
So you're
my phone.
You'll stay with a friend in Lansing?
She's in Charlotte.
What's your phone number?
517-420-9916.
Are you currently on probation or on parole?
No, Your Honor.
I actually don't see any other court or criminal history other than this pending matter. You can address bond counsel.
Thank you, Your Honor. I would ask that the court institute a PR bond with the appropriate conditions. Miss Meredith does have a limited criminal history. She's not on probation or parole and been in the Ingham County area for about 4 years now. She did report one failure to appear, indicating that she was just unaware that she was supposed to appear in court. So I think that a PR bond with the appropriate conditions would be sufficient to ensure my client's appearance as well as to protect public safety. Thank you.
Again, I don't have any prior criminal history, so I don't know what her failure to appear was for. Maybe it was a civil matter. I can't speak to that. However, I am going to grant the request for a personal recognizance bond. It will be set at 500 personal recognizance. You're not to have contact directly or indirectly or through third party with Travis Wageman. Do you understand that?
Yes, Your Honor.
You're not to be within 2,000 feet of wherever he is. You're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. I am going to order that you participate in random urinalysis testing 1 time a week, pending this matter. And you need to report to all of your future court dates. Do you have any questions about your bond?
No, Your Honor.
Any additional matters for the record, counsel?
Yes, sorry, Your Honor, I forgot to mention, Ms. Meredith did ask for a one-time visit with police to get some personal belongings at the 2600 Devonshire address.
I'll allow her to go once with a peace officer to remove personal belongings.
Thank you, Your Honor. Nothing further.
To the extent that they're able to do that, but it's not likely that they'll be able to go with her. She'll probably have to make other arrangements through the court to get a third party. I won't entertain that now until she can figure out who the third party is. And you also need to update the court with your address that you're going to be staying in. You need to do that within 48 hours, okay?
Okay, yes, ma'am, I will. Thank you.
You're all set. Okay, this is the state of Michigan versus Alexandria Perkins. Counsel appearance.
Good afternoon, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Miss Alexandra Perkins, who is appearing from the jail arraignment room via Zoom.
Okay, Ms. Perkins.
Hi.
I do have hi, how are you?
Good, how are you?
I'm well, thank you. I do have here a misdemeanor complaint that alleges that on or about April 11th at 3330 Tecumseh River, City of Lansing, Ingham County, State of Michigan, that you allegedly committed the act of domestic violence and that you made an assault or assault and battery upon a Devontae Cantu. That's an individual that you had a dating relationship or a child in common, and that this is contrary to Michigan Compiled Law 750.812. That's a misdemeanor, and the maximum penalty is 93 days in jail and or $500 in fines. And a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charge there and the maximum penalty, ma'am?
Yes.
Okay, you have the right to be represented by an attorney. You are being represented for your hearing today for arraignment, but you do have the right to have an attorney represent you throughout the pendency of this criminal prosecution, and the right to be represented by counsel if you're going to be questioned by law enforcement. If you cannot afford cannot afford to hire an attorney, you can make a request to have the public defender's office appointed at the expense of the public. Do you understand that?
Yes.
Sheets of paper on here today. Let's see. Okay, you are currently scheduled in this matter to have a pretrial conference before Judge Stacia Buchanan. It's going to be April 28th at 9:30. You should have received notice to appear before Judge Buchanan and Zoom instructions, because you have the option of appearing in person or via Zoom. Do you understand that?
Yes.
And you did receive your notice?
Yes.
Okay, very good. You have the right to plead guilty, plead not guilty, or stand mute. But if you stand mute, the matter will just continue all the way to a trial. And you have the right to have a jury trial. You have the right to be presumed innocent until proven guilty. You have the right to confront in court any of your accusers and cross-examine them. You have the right to put forth defenses at your trial. You have the right to remain silent and not have the silence be used against you. And then you also have the right to subpoena witnesses that will testify on your behalf at the time of trial. Do you have any questions about those rights? Is she making a request for public defense office?
She is, Your Honor.
The court will enter a plea of not guilty on your behalf. Where are you employed?
Carroll Hospital. Well, two of them now. Two of them.
I figured because I see the healthcare fingerprints on here. Okay. And what do you do there?
Nursing, phlebotomy.
And was the address on the complaint, is that your address, the address on Tecumseh, or are you on Elmwood?
I'm on Elmwood, yeah.
Okay, and the alleged victim does not live at Elmwood, is that correct?
Correct.
Is that 311 Elmwood?
Yes.
Okay. What's your phone?
517-944-0419.
I don't see anything additional on her criminal history. You're not on probation or parole, nor do you have any other pending matters, correct?
Correct.
Okay. Bond in this matter will be personal recognizance. It's $500 personal recognizance. There's a no contact order that I'm going to put in place for the protection of the alleged victim, Devontae Cantu. So you're not to have contact directly or indirectly with Mr. Cantu. Do you understand that?
Yes.
You're not to be within 2,000 feet of wherever he is. Do you understand that?
Yes.
You're not to travel outside of the state without first getting approval of the court. You're not to possess a firearm, any other dangerous weapon. You're not to use, purchase, or possess alcohol or drugs during the pendency of this matter. Do you have any questions? I'm sorry?
No.
Okay, any additional matters for the record?
Nothing further, Your Honor. Thank you.
You're all set.
Thank you.
You're welcome. On the record, in the matter of the people of the state of Michigan versus Cedric Boyd, I have 23-02274. And then I have 24-02093, council appearance.
Good afternoon, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Mr. Cedric Boyd, who is appearing from the jail arraignment room via Zoom.
Are you Cedric Boyd?
Yes, I am, Your Honor.
Okay, in the file 23-02274, it looks like you were supposed to be before Judge Flores back on November 12th. You failed to appear. Did you forget about your court date?
Yes, I did, Your Honor.
How did that happen?
I was probably working a lot back, 'cause I used to work a warehouse job at that time. So I was probably working a lot back then. I just forgot about it.
You say you were working a lot of jobs at that time?
Yeah, I just forgot about it. I'm not used to this whole court
Where were you
thing.
working?
At Dakota Warehouse.
You're not used to the court thing?
No, I'm not used to it. I'm just now, getting into this for I be staying out of trouble.
Well, I don't see how you're not used to the court thing. I just called 2 criminal files for you, so that should make you used to it at this point. On top of that, file number, this is a 2023 file. We're in 2025. You failed to appear in August 18th, 2023. You failed to appear July 2024. You failed to appear September 2024. You failed to appear again in November on this file 2024. So how long does it take for you to get used to it?
So them all in 2024?
Yeah, you failed to appear August 18th, 2023. You failed to appear July of 2024. Then you failed to appear in September of 2024. And then you failed to appear in November of 2024, all on that same file. In addition to that, you also have a matter that you were supposed to be in 24-02093. You were supposed to be before Judge Flores on April 1st of this year for a probation violation hearing, and you failed to appear.
Yes, Your Honor. I didn't have a ride at that moment.
Okay, well, we'll see if we can assist you with getting proper transportation to court, okay?
Yes, Your Honor.
We'll have you remanded on the probation file for your hearing, and then that way you can get to court because the Ingham County will transport you, okay?
So what happened? What's
You'll be
mandated?
remanded. That means you're going to stay in jail until you report before the court for the hearing that you were supposed to report to, okay? Because you can't either get yourself to court on your own, nor can you get used to keeping up with your court dates. And so we will assist you the best we can in getting you there, okay?
I can get on my own.
As to the driving unlicensed, your bond will be set in the amount of 300 cash surety. Any additional matters for the record?
Nothing further, Your Honor. Thank you.
You're all set.
Thank you, Your Honor.
Thank you. You're all set. That's all I have for today. They didn't give me the rest of the files.
Excellent. Thank you, Judge.
All right. Thank you. Have a good one.
Yeah, you too. Bye-bye.
Bye.